So, here we'll discuss regarding Article 45, which was inserted under 86th Amendment in 2002 into the Constitution, and this article provides that the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. So, in that connection, we would like to discuss one important reading case, J.P. Unikrishna versus State of Andhra Pradesh in 1993. Supreme Court observed that in respect of the right to education, the contents and parameters is to be determined in the right of Articles 41, 45, and 46. It means free education up to 14 years of age to every child, and after 14 years of age, right gets circumscribed by limits of the economic capacity of the state. And now we'll go to Article 46 and Article 46, under which a direction is given to state that the state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So, in that connection, we would like to discuss the first important leading case, that is Lingappa versus State of Maharashtra. In 1985, Supreme Court observed that a law prohibiting transfer of land belonging to a member of scheduled tribes to a non-tribal is valid. And the second important leading case relating to this provision under Article 46 is the Shanti Star Builders versus Narayan Khimalal Totami. In 1990, Supreme Court expressed that regarding the expression weaker section of the society as it is provided under Article 46, the Supreme Court has directed the central government to lay down appropriate guidelines in determining weaker sections of the society as it is placed under the very direction given to state under Article 46 of the directive principles of state policy. And in that context of Article 46, we would like to discuss another important leading case, that is Biswas Anna Sawant versus Municipal Corporation of Greater Bombay in 1994. Supreme Court expressed that an employee belonging to backward classes has a fundamental right to be considered for promotion on the basis of Article 16. Read with Article 46. M. An employee in the backward class category was granted promotion when he approached the High Court it was held that promotion could not be denied to another employee who was similarly placed, as it was pronounced in this important leading case by the apex court. So, now we'll go to Article 47 of the Directive Principle of State Policy, and that particular direction given to state is that the state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. So, as per the very direction of this article, the state established primary health centers, also community health centers, and also it launched health related programs like National Rural Health Mission, National Urban Health Missions, and it also built hospitals at district headquarters, so also and state level, so also it established dispensaries at different places in state, so also it carried out many programs regarding controlling communicable diseases, so also state brought and carried out many programs and schemes regarding eradicating malaria, malaria, tuberculosis, leprosy, smallpox, and venereal diseases, etc. So, these were the different steps taken by state as per the direction given under Article 47. So, in that connection, we would like to discuss some important leading cases. But before that, we would like to discuss some other major initiatives were taken by the state, such as National Water Supply and Sanitation Program was launched in 1954 by the Union government. So also the Union Parliament enacted Prevention of Food Adulteration Act in 1954. And as relating the important case in relation to this article, first we will discuss this important leading case, that is Rajendra Kumar versus State of Maharashtra. In 2016, the Bombay High Court expressed that Article 14 cannot be relied upon and restored to question any step of state government in an attempt to discharge its obligations under Article 47 of the Constitution. And regarding the most important portion of Article 47, that direction given to state regarding prohibition of the consumption of intoxicating drinks and of drugs which are injurious to health except for medicinal purposes. We would like to discuss Another two important leading cases which we have not mentioned here, one is that all information supplied by applicants must undergo and satisfy the strict scrutiny test as regarding grant of liquor license. The state should not treat its right of parting with its privilege only as a means of earning more and more revenue. The importance of regulation of liquor vis-a-vis public health should be noted as it was decided in the important leading case Ashok Lenka versus Rishi Dikshit in 2006 by the Supreme Court. So also in relating to intoxicating drinks and drugs which are injurious to health and its very prohibition of the consumption. We would like to discuss another important leading case, and that is State of Kerala versus Kandant Distilleries, which was decided in the year 2013 by the Supreme Court, where it was pronounced that, in particular, trade in liquor, a citizen has no fundamental right to trade or business in liquor. The state can prohibit completely trade or business in potable liquor, and the state can also create monopoly in itself for the trade or business in such liquor, as it was pronounced in this 2013 important leading case, State of Kerala versus Kandat Distilleries. And now we'll go to another important article, that is Article 48. And exactly Article 48 provides that the very direction is given to state that states shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other draught cattle. So, in that connection, state had taken many important steps, such as that we have to find in this connection as per the very provision of Article 48 of the Constitution as a direction to state. A number of projects were launched with the purpose of better utilization of river waters for irrigation, for generating electricity and power, and for flood control. And some of these were such hydroelectric projects where the Nagarjuna Sagar project of Andhra Pradesh and the Tungabhadra project of Andhra Pradesh and Mysore or Karnataka, then the Gandak project in Bihar and Uttar Pradesh, the Kosi project in Bihar, the Chambal project in Madhya Pradesh and Rajasthan, the Hirakud Dam project in Odisha, the Bhakra Nangal project in between Punjab, Haryana and Rajasthan, the Faraka project in West Bengal and the Damodar Valley Corporation project in West Bengal and Bihar. So also in 1969, the Seeds Act was enacted and the National Seed Corporation supplied seeds of high yielding varieties of seeds. So also state established the Food Corporation of India and also the Fertilizer Corporation of India, and as per regarding the preservation of the surplus food production and regarding production and manufacture of fertilizers. It also established the Fertilizer Corporation of India, and as regarding HYB seeds, the high yielding variety seeds, as a part of Green Revolution, which was launched in the state of Punjab in the 1960s due to the initiative of the Nobel Peace Laureate Dr. Norman Borlaug, the American agricultural scientist, with the Indian agricultural scientist Dr. M.S. Swaminathan, who worked for the growth of different kinds of seeds in India, and in particular on wheat in Punjab, Haryana, and Uttar Pradesh. So also the state established the Indian Council of Agricultural Research and carried out education and research in the field of horticulture, livestock, intensive cattle development projects. So, in that connection, we would like to discuss one important leading case, that is state of Gujarat versus Mirzapur, Moti Qureshi, Kasab Jamat. In the year 2006, Supreme Court made the observation that the relating to the very second part of the provision, that is dealing with prohibiting the slaughter of cows and calves and other drought cattle. So, in that connection, it was a major pronouncement by the Supreme Court in this leading case, state of Gujarat versus Mirzapur, Moti Qureshi, Kasab Jamat in 2006, where it was pronounced that having specifically spoken of cows and calves, the framers of Constitution into Article 48 choose not to catalog the list of other cattle and felt satisfied by employing a general expression of other mixed and drought cattle, which, in their opinion, any reader of the Constitution would understand in the context of words cows and calves, as it was pronounced in this important leading case, which is falling under the provisions of Article 48 as the direction given to the state of Gujarat versus Mirzapur, Moti Qureshi, Kasab Jamat in 2006. And now we'll go to Article 48A, and it was inserted under 42nd Constitutional Amendment Act 1976, where the very direction given under this Article 48A is that the state shall endeavor to protect and improve the environment, to safeguard the forest and wildlife of the country. So, in that connection, we would like to discuss some important leading cases such as Satish versus State of Uttar Pradesh in 1992. Supreme Court expressed that through public interest litigation brought by an institution in the locality on the basis of Article 21, the duty under Article 48A can be enforced. And now we'll go to the second important leading case in relating to Article 48A is MC Mehta versus Union of India in 1992. It was pronounced that duty under Article 48A can be enforced through even a letter based on Article 21. And now we'll go to another important leading case relating to Article 48A is Intellectual Forum Tirupati versus State of Andhra Pradesh, and it was a case of 2006 decided by the Supreme Court where it was pronounced that merely ascertaining an intention for development is not enough to sanction destruction of local ecological resources. As regarding environment protection vis-a-vis social development, as it was pronounced in this 2006 Supreme Court case, Intellectuals Forum Tirupati versus State of Andhra Pradesh. And now we'll go to another important leading case, that is Arjun Gopal versus Union of India in 2017 Supreme Court on the very protection of environment. Environment expressed that the use of fireworks in national capital region or the national capital territory of New Delhi is major source of noise and air pollution, causing immense harm to lives and health of citizens. It is the duty not only of the state but also of the citizen to ensure healthy environment. So it is one of the major important decision tendered by the Supreme Court in 2017 relating to protection of environment due to the pollution and noise created by the fireworks. And now we'll go to another important leading case relating to Article 41, that is Center for Environmental Law. World Wildlife Forum of India versus Union of India in 2013 Supreme Court observed that it is the duty of the state as a custodian of the natural resources has a duty to maintain them not merely for the benefit of the public trust but for the best interest of flora and fauna, wildlife, and so on, as it was pronounced in this important leading case in 2013 by the apex court. Center for Environmental Law, World Wildlife Forum of India versus Union of India. So, in this video, we have finished up to Article 48A, and in our next video, we would like to discuss Article 49, which relates to protection of monuments and places and objects of national importance.